And number 60, United States Appellant versus Cecil Ray Price. Sit down. Mr. Solicitor General.
Mr. Chief Justice, may it please the Court, these cases, as all the world knows, arise out of a brutal incident during the summer of last year in the town of Philadelphia in the county of Neshoba in the state of Mississippi, which culminated in the murder of 3 young civil rights workers, Michael Schwerner, James Chaney, and Andrew Goodman. These federal prosecutions are brought under sections 241 and 242 of the Criminal Code, in which some 18 persons, 3 of them public officials, are accused of having joined together to deprive the 3 young victims of their civil rights. The actual facts cannot be detailed because no trial has taken place and the evidence has not been produced. All that's before the court today is a bare charge consisting of 2 indictments. The only question here is whether those indictments, assuming the facts alleged can be proved, state offenses against the United States. The overall charge is that the 18 defendants conceived and executed a criminal plan directed against the 3 victims. It is alleged that the 3 of the defendants, namely the sheriff of Neshoba County, his deputy, and a local policeman, used their official powers to release the victims who were in state custody, turned them over to a lynch mob, which one of the officers had shielded by his presence, with a view that they be summarily punished without benefit of trial and as alleged in defiance of the Due Process Clause of the 14th Amendment. The indictment in number 59, which is only 1 count, charges a conspiracy that was charged to be in violation of Section 241. The whole of that indictment was dismissed as to all defendants. The first count of the indictment in number 60 is the same conspiracy as charged as a violation of the general conspiracy statute, Section 371 of the Criminal Code, as a conspiracy to commit the offense defined in Section 242. That charge was sustained by the district court as to all defendants. The 3 other counts of indictment, the indictment in number 60, charge all the defendants with substantive violations of Section 242 by executing the criminal plan with respect to each of the 3 victims. The district court sustained those counts as to the 3 state officials, the 3 state law enforcement officers, but dismissed on all 3 counts as to all other defendants.
Were the individuals, the private individuals in the substantive counts charged as aiders and abettors?
Not specifically so, except in one portion. The aider and abettor statute, we take the position is there whether or not. It's 242, 242, each one says 242, in violation of Section 242. Yes, sir. It's our position. Because as we see it, when state officers are involved, and then the conspiracy moves in charging the state officers and the individuals together, but it would not apply, of course, unless the state officers were there, and in this case, the state officers are there. I think I'll clear it up a little later on that. The gravamen of both indictments is the allegation of a conspiracy to willfully subject the victims to the deprivation of, quote, their right, privilege, and immunity secured and protected by the 14th Amendment to the Constitution of the United States not be summarily punished without due process of law by a person acting under color of the state of Mississippi. End of quote. That's in the indictment. A particular section is quoted from page 12 and 13. And before going any further, I want to explain the relationship between this case, and more particularly number 59, and the Guest case to be argued next. This case is really the preamble to the Guest case. There is no Guest case unless we prevail in this case on the main point, which is that Section 241 protects 14th Amendment rights. The two cases are thus very closely related, yet I would like to stress the differences. The basic factual difference, of course, is that here the state itself, through its law enforcement officers and their confederates, charged with invading the civil rights of citizens, while in the Guest case, the interference is directly attributable solely to private individuals. Here, there is no question that violations of the 14th Amendment are alleged. There's no question about it as I see it. And indeed, the district judge so found by sustaining the charge of conspiring to violate 242, which he held as to all of them. The only question in this case, I repeat, is whether 241 encompasses 14th Amendment rights at all. And that is not a constitutional question, at least since the Screws case. There can be no doubt whatever about the power of Congress to make it a federal crime for state officers to deprive citizens of their constitutional rights, even if the conduct also violates state law. The sole question here is one of statutory construction. Did Congress mean to reach violations of the 14th Amendment in Section 241? On the face of the statute, it is difficult to see how any such question ever arose. Indeed, Section 241 punishes interference with exercise or enjoyment of, quote, any right or privilege secured by the constitutional laws of the United States. And certainly the 14th Amendment is a part of that Constitution. And certainly the 14th Amendment confers, quote, rights or privileges, end quote. Why would 14th and 15th Amendment rights not be embraced by the provision? One could imagine a doubt if the statute had been written before the 14th and 15th Amendments became part of the Constitution. But that's not the fact. On the contrary, Section 241 was enacted in May of 1870, less than 2 years after the ratification of the 14th Amendment and only 2 months after the ratification of the 15th Amendment. As a matter of fact, Section 241 is a part of the first civil rights law passed after the adoption of the amendments. The natural assumption is that the new statute was peculiarly concerned with protecting these new constitutional rights. Is there anything in the conditions of the time that suggests that Congress was focusing on rights derived from the relationship of the citizen to the national government, rather than the relationship between the citizen and his state government? The time, I repeat, was 1870. This was a Reconstruction measure. The problem then was of assuring equal rights and protection to the new freedmen who were the victims of racial antagonism. Against that background, it seems obvious that when Congress spoke of constitutional rights, it meant to include those derived from the Due Process and Equal Protection Clause of the 14th Amendment and the right to freedom from racial discrimination and exercise of the right to vote guaranteed in the 15th Amendment. As a matter of fact, in the case of Strawder against West Virginia, and it seems as though these two cases, Strawder and Ex parte Virginia, constantly come forward again, but I think it's well at times to read it again. The 14th Amendment, Strawder says, the 14th Amendment makes no attempt to enumerate the rights it designed to protect. It speaks in general terms, and those are as comprehensive as possible. Its language is prohibitory, but every prohibition implies the existence of rights and immunities, prominent among which is the immunity from inequality of legal protection, either for life, liberty, or property. Any state action that denies this immunity to a colored man is in conflict with the Constitution. and in ex parte Virginia. Mr. Justice Strong continued, quote, one great purpose of these amendments was to raise the colored race, he was speaking of the 13th and 14th Amendments, was to raise the colored race from that condition of inferiority and servitude in which most of them had previously stood into perfect equality of civil rights with all other persons within the jurisdiction of the states. They were intended to be, and they really are, limitations of the power of the states and enlargement of the power of Congress. I repeat, enlargement of the power of Congress. They are to some extent declaratory of rights, and though in form prohibitions, they imply immunities, such as may be protected by congressional legislation. Now that was the real problem. It was not the problem of interference with the homesteading laws or the federal privilege to inform on violations of tax laws. The indictment alleges here more than ordinary murder for personal reasons by a group of individuals, some of whom happen to be state officers. One, it is alleged that the state law enforcement officers were acting on the color of their office. And two, it is further alleged that they used their official powers to release state prisoners, turn them over to a lynch mob, which was shielded by the presence of another state officer, so that they could be summarily punished without benefit of trial. This, to my mind, puts this case squarely within the rule announced in the Screws case, and indeed within the rule announced in the Williams case, at least insofar as Mr. Justice Douglas' opinion was concerned. In the Screws case, there was no problem with the indictment. No court found any problem with indictment in that case. And in the Williams case, if you read the indictment was closely similar to the one here. Finally, is there something in the debates underlying the enactment of Section 241 that contradicts the apparently clear text of this statute, which I think most certainly clearly applies here? Despite the language and the historical context which point unmistakably to a congressional intent to protect 14th and 15th Amendment rights as rights and privileges, is there some evidence buried in the legislative history that shows a different focus? There is nothing of the kind. What became Section 241 was an amendment to the Enforcement Act of 1870, proposed by Senator Poole of North Carolina. He proposed the amendment. And he made his purpose very clear, and there is nothing in the congressional record to the contrary on this particular amendment. The only relevant speech is his own, when he first explained the object of his amendment. We have reproduced the entire speech of Senator Poole in an appendix to our brief on the merits, and it bears out what I've said. The senator begins by making it clear that this is a Reconstruction measure. It is entering upon a new phase of Reconstruction. That is, he says, to enforce by appropriate legislation those great principles upon which the Reconstruction policy of Congress was based. He then tells us more particularly the conditions he is concerned about. And he says, quote, the equality which by the 13th, 14th, and 15th Amendments has been attempted to be secured for the colored man has not only subjected them to the operation of the prejudices which had theretofore existed, but it has raised against them still stronger prejudices and stronger feelings in order to fight down the equality by which it is claimed they are to control the legislation of that section of the country. They were turned loose among those people, weak, ignorant, and poor. Those among the white citizens there who have sought to maintain the rights which you have thrown upon that class of people have to endure every species of proscription, of opposition, and of vituperation in order to carry out the policy of Congress. In order to lift up and to uphold the rights which you have conferred upon that class, it is for that reason not only necessary for the freedman, but it is necessary for the white people of that section that there should be stringent and effective legislation on the part of Congress in regard to these measures of Reconstruction. End of the quote there. Though most of his speech is directed to the 15th Amendment, Senator Poole very plainly puts 14th Amendment rights, and particularly those derived from the Due Process and Equal Protection Clauses, on the same footing. There is first the long passage quoted in our brief at page 40 and 41, which he emphasized the word deny in those clauses. And he says, quote, the word deny is used not only in this 15th Amendment, but I perceive in the 14th Amendment it is also read. End of quote. And again later, when he is speaking of the need to teach or to reach unofficial conspiracies, the Senator explicitly refers to the 14th Amendment. And he says, quote, but, sir, individuals may prevent the exercise of the right of suffrage. Individuals may prevent the enjoyment of other rights which are conferred upon the citizen by the 14th Amendment, as well as trespass upon the right conferred by the 15th. This last statement from Senator Poole's speech, emphasizing his concern with unofficial action, particularly conspiracies like the Klan, which he explicitly mentions, suggests the only argument against reading Section 41 to reach 14th and 15th Amendment rights. It has been said that because this statute, unlike 242, is not confined to acts done under color of law to officials, it cannot have been meant to protect 14th and 15th Amendment rights, which can only be invaded by state officers, or at least by persons acting under color of state law. As Mr. Justice Douglas pointed out in his opinion for the 4 justices in the Williams case, the conclusion does not inexorably follow from the premises. Even if the Congress of 1870 had believed that it could not reach private individuals who interfered with the exercise of 14th and 15th Amendment rights, but wished to write one provision which protected all constitutional rights, it might well have written the same words we find in Section 241. Or rather, they could let the Constitution itself operate to confine the class of those who had capacity to commit the crime where the 14th or 15th Amendment was involved. That is indeed exactly what Congress did. But the true explanation is that neither Senator Poole nor the Congress of 1870 saw any problem with this. They thought, rightly or wrongly, and we believe they were right, as we will argue in the Guest case, that they could constitutionally reach private conspiracies hostile to the 14th and 15th Amendments. You cannot read Senator Poole's speech without reaching that conclusion. And if any further proof were needed, you only have to look at the Klan Act of 1871, which is caught invalidated in the United States against Harris. Now, as I have said, we think the Congress of 1870 was right in its premise. But it does not automatically follow that the question in this case depends upon a case where there are no state officers involved. If only persons acting under color of law can be reached in enforcing the 14th and 15th Amendments, then Section 241 must be read accordingly. It would be nonsense, I say, to say that the Congress of 1870 did not mean to reach any interference with 14th or 15th Amendment rights, because they thought they were reaching something that the inference would not allow them to reach. I say that on the particular point involved here, that first of all, we have to make our position clear, and that we are not here asserting that Congress intended to cover every crime committed under state law. And indeed, in all of the briefs on the other side, it's alleged that this is peculiarly state or crime or what have you. But I respectfully would call the Court's attention to the 1884 decision in the Waddell case. And speaking of the same provision, said, quote, "The right here guaranteed is not the mere right of protection against personal violence. This, if the result of an ordinary quarrel or malice, would be cognizable under the laws of the state and by its courts. But it is something different from that. It is a right to remain on the land in order to perform the requirements of the Act of Congress and, according to its rules, perfect his incipient title. And under the Wardell case, I think the same provision would be here. If the defendants in this case were merely out to commit an ordinary crime, quote, as a result of an ordinary quarrel or malice, end quote, it would be strictly state, but that is not the case. I believe, as I said earlier, that the two cases which control this case are the Screws case and United States against Williams. And I think it's very interesting that everybody relies on United States against Williams. And I would like for a moment to explain our position as to the case. In the first place, the decision was 4-4 with Mr. Justice Black concurring on a different point. But as to the points involved in this case, it was definitely a 4-4 decision. And the language in the what is labeled the dissenting opinion of Mr. Justice Douglas, concurred in by Mr. Justices Reed, Mr. Justice Burton, and Mr. Justice Clark, they trace the whole history of these sections, both of the sections, and brought the sections up to date, both 19 and 20. And I have no need to go back further in this, because in both of the opinions in the Williams case, Senator Poole was referred to. The only addition we have made in our position in this case is to print more fully the whole argument, or rather the whole speech made by Senator Poole. And in the Williams case, after the language, the constitutional history, the congressional history rather, was reviewed, and the Screws case was reviewed, that opinion made it quite clear that 14th Amendment rights were to be protected. And in this particular case, you add the fact that as to the 14th Amendment rights, in the three latter counts in the number 60 case, the court actually held the state officers to be liable. And then, with the same vein, comes back and says, but it does not apply. It seems to me that you can't say the 14th Amendment applies one place and does not apply in the other particular position. The emphasis in the second emphasis was on Senator Poole's speeches, which we have quoted. And in the Williams case, it was pointed out that, as Mr. Justice Rutledge stated in the Screws case, there is no difference between Section 19 and Section 20 so far as the basic rights guarded are concerned. The coverage of the two sections is not coterminous. The difference is not merely on the fact that 19 covers conspiracies and 20 covers substantive offenses. Section 20 extends only to those who act under color of law, while 19 reaches two or more persons who conspire to injure any citizen in the enjoyment of any rights or privilege secured to him by the Constitution. The reach of 20 over deprivations of rights protected from invasion by private persons is therefore, in this one respect, less than that of 19. But this is no comfort to the respondents in the present case. It certainly cannot be doubted that state officers, or those acting under color of state law, who conspire to wring confessions from an accused by force and violence, are included in the phrase two or more persons within the meaning of Section 19. And that, from the Williams case, it seems to me, applies in this particular case. And if there are no further questions, I would save some time for rebuttal.
Mr. Watkins.
Mr. Chief Justice, if it please this honorable court, on behalf of the appellees, directing my remarks first to the matter of jurisdiction in case number 59, as stated in our brief. we believe certainly that this honorable court has jurisdiction to review on direct appeal case number 59. The district court, in regard to case 59, in dismissing the indictment, holding that it did not state a cause of action against the United States, as the charge was made under 241, restricted in his opinion that 241 reached interferences with the rights and privileges of the citizen in relation to the federal government, rights and privileges arising from the substantive powers of the federal government. In case number 60, as already stated, the indictment stands as against the officers, the three officers in that case. The indictment also stands in count 1 against all the defendants, as the charge was in violation of 371, Title 18, United States Code. The statutes, if it pleases court, that were before the district court, as we understand it, was 241, 371, and 242. No indictment in either case made any reference to Section 2, Title 18, United States Code, having to do with the aiding and abetting statute. Our proposition then on behalf of the appellees is that Section 241 of the Criminal Code does not reach interferences with the exercise of natural rights of the citizen or the inhabitant, and such interferences are not encompassed by the Due Process Clause of the 14th Amendment. Certainly, equality and equal protection under the law is a right and privilege of every American citizen and or inhabitant. And it stands without debate that it is the duty of every Republican government to protect that equality and right under the law of every citizen and every inhabitant of this our great country. But as it has to do with harm or injury by one citizen as against another citizen in regard to his natural rights, we respectfully submit that punishment for that type wrong is reserved to the respective states under the 10th Amendment of the Constitution. The 14th Amendment guarantee is the guarantee against encroachment of the individual rights in regard to encroachment by the state. 242 certainly reflects the power of the Congress to pass laws to enforce any encroachment of the 14th Amendment guarantee. And they did that in passing Section 242, the color of law statute. Therefore, generally our contention is that 241 reaches interferences with the exercise of those rights and privileges arising from the substantive powers of the federal government. Those rights and privileges arising because of the relationship of the victim and the federal government, and not the general guarantee of the Due Process Clause and equal protection of the 14th Amendment encompassed by 242 as action of the state. We feel that the cases of Logan, Yarber, Gwynn, and Classic, Saylor, Waddell, Quarles, and others cited in the brief support that position. Let's make reference a moment to the statute 242 and 241 in regard to the differences in those two statutes. 241 creates a misdemeanor. It speaks of color of law, directing its meaning directly to the 14th Amendment, having to do with the guarantee against encroachment by the state. It speaks of color or race.
You're referring to 242 now?
Yes, Mr. Justice, 242.
241.
Excuse me. I'm referring to 242. It creates a misdemeanor. It speaks of color of law. Has to do with color or race. Has to do with inhabitants. In addition to the citizen. It punishes criminal acts, not conspiracies. 241 has to do with conspiracy only, not substantive criminal acts. It has to do with a felony, wherein 242 has to do with a misdemeanor. It makes no reference whatsoever to color of law, as does 242. It deals with the rights of citizens, and it creates an independent crime going on the highway to do the wrongful acts stated therein. Therefore, as to the language of the indictment in number 59, when that language speaks of color of law is referred to in both indictments, in number 59 and in 60. But when it's used in number 59, that language alone, we contend respectfully, cannot extend 241 to the 14th Amendment guarantee. Cannot make a misdemeanor a felony by simply using the terminology under these things were done under color of law when it's drawn under 241.
241 is a felony.
Mr. Justice, I did.
241 is a felony?
Yes, Mr. Justice. 241 is the felony. And 24.
It was dismissed in its entirety.
Yes, sir. It
While
was.
the 242 was held against the officers, but not the civilians.
That is correct, Mr. Justice. 242 stands as against the officers, and the charge of general conspiracy under 371 now stands against all the officers and the private individuals, if Your Honor please, at this time.
What was the theory of dismissal on 242 against civilians?
We contend in number 60, Your Honor please, that the theory of dismissal of 242 as against the private individuals, as we understand the court's ruling, had to do with a matter of fact, in that the indictment did not charge anything that they did in fact, or did not make them in fact or de facto acting under color of law, in that they did not flash a badge as in Williams versus United States, or did not represent themselves to be officers of the law. We understand that to be the reason for the dismissal of the private individuals under 242. Mr. Justice, if the indictment had specifically alleged that the private individuals were aiding and abetting and had directly brought Section 2, Title 18 U.S.C.A. before the Federal District Court, it's my honest opinion that that indictment in regard to the aiding and abetting statute would have stood.
You think they'd have to use those words, aiding and abetting?
Mr. Justice, I feel like that the district court could not assume the position of prosecutor that it was the duty of the department to direct the violation as going against Section 2, Title 18, the aiding and abetting statute. If the Justice Department intended that that statute be used, it should have been brought to the attention of the district court, is our position in that regard.
I don't quite get that. You mean brought to the attention without any express allegation in the indictment?
Mr. Justice, we feel like that in the indictment, since it referred that these violations are in violation of 242, 241, and 371, that that same allegation should have been made in regard to Section 2.
In the indictment
In the
itself.
indictment.
Yes.
Yes, sir.
The indictment did allege that the officer released these parties.
As the plan and purpose, Mr. Justice, the indictment in number 59 and the other indictment for that matter went on to say that as a matter of plan and purpose that it was the purpose of the law enforcement officers that these named victims be released and that they be intercepted after the release and that assault and battery and murder be committed. That was the phrase.
By the private individuals.
All the defendants named.
By all of them.
Yes,
including officers as well as private individuals.
yes, sir. It is crystal clear to us that Section 242 encompasses 14th Amendment rights, and that certainly it was the purpose of Congress to reach actions under color of law under 242. 242, along with 371. 371 making the private individuals vulnerable to prosecution as they act with law enforcement officers under the general conspiracy statute. Then our contention is that without overlapping, 241 should be restricted to federal type rights. It is our position that in effect the contention of the government here is that 241 should reach rights or interferences with the right to be free of assault and murder if it not be restricted. Surely it would be conceded in cases like Yarber, Logan, Quarles, and others that this honorable court emphasized federal type rights or relationship of the victim and the federal government. No state action was involved in those cases. The 14th Amendment rights, we contend that only state action can deprive a citizen or inhabitant of 14th Amendment rights, as the 14th Amendment reads. Let's take, for instance, a biracial school system. The private individual not acting under color of law has no duty to furnish a non-discriminatory education to others, but the state has that duty under the 14th Amendment of the Constitution, Equal Protection Clause, in reference thereto, to furnish non-discriminatory education. In the Wheeler case, the right there involved was to move from place to place, ingress and egress therefrom. The principle of 241 was not extended because it had to do with a natural right. In the Hodges case was a conspiracy, a natural right, the right not dependent upon the Constitution of the United States, that natural right of man that has been endowed by his Creator and doesn't depend upon government. That right to be free of assault and battery, free of false imprisonment and murder, a natural right. In the Hodges case was a conspiracy to prevent citizens from disposing of their labor as they saw fit under labor contracts. The right to work not dependent upon the Constitution, and 241 was not the principle of 241 was not extended in that case. In the Yarber case was a habeas corpus case, a charge in regard to intimidation of citizens relative to the right to vote for a federal officer. Section 241 was extended. It reached that type of interference because it's an interference with a right arising based upon the substantive powers of the federal government. The court in effect held that in that case that the right to vote was of such supreme importance that it was necessary to the governmental function, that it was of such importance that the 15th Amendment was passed to guarantee that there be no encroachment by the state or by the federal government against that right to vote. In the Yarber case,
I suppose until the 15th Amendment the right didn't exist, did it?
Mr. Justice, the right to vote for a congressman arises under Article 1, Section 2 and 4 of the United States Constitution. The inherent makeup of the government under the Constitution gives the citizen the right to vote without regard, we respectfully submit, to the 15th Amendment. The 15th Amendment, as the 14th, was a guarantee that there be no encroachment by the state or the federal government on that right to vote, such as the case is holding that the respective state has a right to set the standard of voting. But if that standard, through color of law, be repugnant to the 15th Amendment, it will be stricken down. In the Yarber case, and I, with permission, quote from the Yarber case, the reference to cases in this court in which the power of Congress under the first section of the 14th Amendment has been held to relate alone to acts done under state authority can afford petitioners no aid in the present case. For while it may be true that acts which are mere invasions of private rights, which are not committed by anyone exercising state authority, are not within the scope of that amendment, it is quite a different matter when the Congress undertakes to protect the citizen in the exercise of rights conferred by the Constitution of the United States, essential to the healthy organization of the government itself. And the habeas corpus writ was denied. Does the extension of the protection of 241 in the voting right cases rest on the 15th Amendment? We contend that it does not. There's perhaps no difference in the guarantee of the 14th Amendment and that of the 15th Amendment in that it guarantees there will be no encroachment by the state, and same language in the 15th, including the state and the federal government. We contend that the right to vote arises from other sections of the Constitution.
What section?
Article 1, the inherent makeup of the government as set out by Article 1, Section 2 and 4.
Could you tell us the specific provisions of the Constitution which you consider are encompassed in 241, which you say doesn't reach 14th Amendment?
Your Honor, we contend that...
What are the, not natural rights, but constitutional rights?
We contend that those rights arising from the exercise of the substantive powers of the government, whatever they may be, is reached by 241 and should therefore be restricted to those rights and privileges arising from the exercise of the substantive powers of the government, or the relationship of the victim and his government, whatever federal type right that might be, is reached by 241, such as taking a prisoner from the custody of a United States Marshal, the right to vote, the right to homestead land, any other right arising because of the substantive powers of the federal government to that individual and his relationship. And that is without regard to any particular section, as we understand it, Mr. Justice.
Do you find that reflected in the debates? 241.
Mr. Justice, we feel like that the decisions as cited in the appellee's brief leading up to United States versus Williams reflects that the court from time to time sought to restrict 241 without regard to what the particular right might be to those rights and privileges arising from the substantive power of the federal government. And in that regard, we do feel like that the cases leading up to United States versus Williams brought forward that theory. Yes, sir. In the Hodges case, there was a charge under 5508, which is the same as 241 now, in regard to intimidations relative to the right to work. The court, in effect, held in that case that the 15th Amendment and the 14th Amendment were restricted to state action, and that there was no state action involved in regard to the right to work. There was a natural right and was protected by the laws of the respective states. In the Quarles case, had to do with the right of one citizen to inform on another citizen concerning the violation of the Internal Revenue Code in regard to a distillery. And the court held that that right to inform, was a constitutional right necessary for the enforcement of the substantive powers of the federal government, and that principle of 241 should reach that type circumstance and be protected. And quoting from that case, such rights arises out of the creation and establishment by the Constitution itself of a national government, paramount and supreme within its sphere of action, and citing the Logan case also. In the Logan case, as mentioned a moment ago, a prisoner was in custody of a United States Marshal, and the named defendants allegedly took the prisoner from the custody of the United States Marshal and committed wrong against his person. The court, in effect, held there that it was a interference, a direct interference with the substantive powers of the federal government to protect a prisoner in federal custody. The Waddell case, as mentioned in the initial argument by the government, had to do with the right of homesteading land. And it might be said in that case that It makes no difference whether the land is being homesteaded by a citizen or inhabited. The principle there sought to be advanced in regard to protection afforded by 241 was that the perfection of the title was wholly dependent upon a federal act, the Homestead Act. The exercise of those rights and privileges arising from the substantive powers of the federal government. What are the substantive powers of the federal government? We contend that they are those powers necessary for the completion of the meaning and purpose of the Constitution, whether they be expressed by some particular section or be inferred. Rights arising therefrom, as stated by the earlier cases, the right to vote, the right to protection in the custody of U.S. Marshal, and so on. The freedom from self-incrimination, double jeopardy, and so on. And yes, due process as to the guarantee of the 14th Amendment against encroachment by the state. On page 7 of the government's brief, it is contended, and they say due process rights have been made definite by the decisions of this honorable court, and they cite the Screws case and United States versus Williams. And certainly, due process in regard to those cases were made definite, but we respectfully point out that those cases had to do with 242 and 371. It's interesting to note that in the Screws case, there was an original charge in that case under 241, as in the case at bar. 241 was dismissed in the Screws case in the lower court, and the government abandoned it in regard to the appeal. And when it reached the higher court, the sections 242 and 371 were involved in that case. On page 9 of the government's brief, it's contended that, and the question is asked, does 241 reach invasion of rights guaranteed by the 14th Amendment? Actually, we could say that can an individual, if he does not act under color of law, invade the 14th Amendment rights? The protection, we contend, extended by 241, that is, the 14th Amendment and the 15th Amendment are not exponents of 241 as such. On page 10 of the brief, the government contends that 241 reaches the 14th Amendment guarantee, or that the rights guaranteed by the 14th Amendment comes within 241 because of the language of the statute, its text and context, and its legislative history. And then in the government brief, as stated in the appendix, the entire speech made by Senator Poole is there printed. We respectfully call the Court's attention to what Mr. Justice Frankfurter said in regard to the legislative history of 241 in United States versus Williams. And we ask permission to read a short quotation from that case. Mr. Justice Frankfurter said, "We base our decision on the history of 241. Talk about history? That's the history he based it on. We base our decision on the history of 241, its text and context, the statutory framework in which it stands, its practical and judicial application, controlling elements in construing a federal criminal provision that affects the wise adjustment between state responsibility and national control of essentially local affairs. The elements all converge in one direction that leads us to hold that Section 241 only covers conduct which interferes with rights arising from the substantive powers of the federal government." We respectfully submit that Mr. Justice Frankfurter considered the legislative history when he made that statement.
Counsel, may I ask you this question? Suppose that this indictment had charged that the purpose of the conspiracy was to prevent the persons who were murdered from leaving the state of Mississippi and returning to, let's say, New York. Would that make any difference in your analysis?
Mr. Justice, Please, sir, in a case referred to earlier, they had the right to do with ingress and egress and to move from place to place. We respectfully submit that the move from place to place, as long as there's not some interference with interstate commerce, would be also a natural right of every individual.
Well, if this were property going from Mississippi to New York, it would be interstate commerce, wouldn't it?
Whether it would be an interference with the substantive powers of the federal government in regard to the power to regulate interstate commerce, I would feel like it would depend upon the charge and the indictment to some extent. But as long as it would have to do with moving from place to place as the right of every individual, that it would be a natural right, and the principle of 241 would not extend to it.
Well, I don't want to press you, but I am having difficulty with the concept of natural rights in this context, and that's the reason for my question, because I'm trying to postulate an indictment in which the interference is specifically alleged to be an interference with the movement of people from one state to another state, which in ordinary legal parlance is considered to be interstate commerce.
Yes.
And what I'm trying to find out from you is whether you would consider that to be within this category of natural rights, whatever they may be, or whether you would consider this to be an interference with a federally protected right, namely the right to move from state to state.
John, we have one case cited in the appellee's brief wherein it has to do with a treaty of China wherein certain persons named therein were charged with the intimidation of certain Chinese people, trying to make them move from a certain locality of the state and to move out and vice versa. And the court held in that case that the principle of 241 did not extend in that instance. If we could relate it, the hypothetical more closely to interstate commerce powers, if it were an interference of the substantive rights of the federal government in regard to the function of interstate commerce, and the facts were so alleged in an indictment, I have no doubt of what 241, the principle of 241, would reach any conduct that was charged in the indictment in such a manner as it would have to do with the interference of rights or privileges arising from the substantive powers of the federal government, whether it be interstate commerce or any other phase of federal government power. Is best I can answer that question. On page 13 of the government's brief, they contend, the government contends that the courts prior to the Williams case take it for granted that 241 covered 14th Amendment rights. And the reason is brought forward there that it was assumed that the courts prior to Williams presumed that it reached the 14th Amendment guarantee in that the courts would determine that the conduct charged did not come within the guarantee of the 14th Amendment. We respectfully submit that whether 241 be restricted to federal-type rights or whether we say that the conduct charged does not come within the protected guarantee of the 14th Amendment is exactly the same result. Whether the conduct charged comes within the guarantee or whether the 241 be restricted amounts to the same thing. If 241 is unrestricted, we feel like in effect it would amount to an amendment of the 14th Amendment by extending 241. In that regard, we feel like that in effect it would amount to the same thing as adding the word person in the amendment. In the appellee's brief on page 3, the 14th Amendment, first section, is cited. And with permission, we read to make our analogy. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. If we do not restrict 241 and extend it to protect the guarantee, it would in effect change it to this effect. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state or person deprive any other person of life, liberty, or property without due process of law. We respectfully submit that in regard to 242 and 371, which reaches private individuals, whether they act with officers or not, in violation of 242, that the answer is if the penalty is not great enough in 242 or 371, rather than to try to reach a felony section 241, that the answer is an amendment in regard to the penalty of 242 and 371, making felonies of those sections, rather than to extend 241 and try to make it reach the 14th Amendment guarantee. Whether it be the obligation of a nation, state, or an individual, perhaps a simple analogy could be used here. For argument's sake, let's say that A gives C a guarantee to protect him from B. But D comes in and harms C. It's obvious that it does not come within the guarantee. The guarantee of the 14th Amendment is that the state, B, will not encroach upon the right of the individual in regard to equal protection under the law and due process of law. But whether or not the conduct charged in the indictment comes within the guarantee of the 14th Amendment, or whether we restrict 241 to federal-type rights, in result is exactly the same.
Is it part of your argument that that there would be a lack of federal constitutional power for Congress to have enacted a statute as construed by the Solicitor General?
Oh, no, sir.
Federal constitutional power under any of the Constitution or any of its amendments?
Mr. Justice Stewart, the Congress certainly had power to enforce the 14th Amendment, and we say
yes,
that
the 14th Amendment, but I had understood that you to say that this statute, if construed by, as the Solicitor General would have us construe it, is not proper legislation under the 14th Amendment.
Oh, no, sir. Your Honor, we intended to leave the impression that Congress certainly had the power to enforce the 14th Amendment and any other amendment, and that they did exactly that in passing 242, but that they had something else in mind in passing 241, that is, the restriction of 241 in regard to the rights that has been held by the cases heretofore, that it protects those rights arising from the substantive power of the federal government. Certainly we do not contend that 241 is not valid because of vagueness or otherwise, and that 241 does not serve a good purpose.
Well, do you think it would be within the constitutional power of Congress, Congress purporting to exercise its power, the power given to it under the 14th Amendment, to make it a federal offense to commit the crime of murder in any state?
Well, yeah, Mr. Justice, Senator Poole, in the argument that the government referred that he made at the time these sections were being passed, argued that point that all crimes committed that occurred while this under color of law wrong was being done should be prosecuted direct by the federal courts. But the Congress at that time did not see fit to extend that principle.
Well, I don't know that I understand your answer to my question.
Whether the Congress has a right,
has the power,
the power to pass a law that would enable federal courts to prosecute any crime that was committed
specifically
during
murder. Let's say Congress, over here across the way, Congress duly assembled, said we're now going to exercise our power as we understand it under the 14th Amendment and make it a federal offense for anybody to murder anybody else in any state of the United States.
Well, Your Honor, please, the best way that I could answer that
You think that's within the power given to Congress by the 14th Amendment, is my question.
the best way I could answer that is that since it's not enumerated as being a federal power, that the Congress would have the power to pass any law that they saw fit in regard to any crime being prosecuted. Whether or not at that time it would be construed by the courts as to be an extension of the power in regard to the reservation to the respective states under the 10th Amendment, I do not know. But I do feel like that the Congress would have power to pass any law they felt necessary in regard to the protections of the guarantees under any of the amendments, and to also prosecute crime.
I'm asking you if you think Congress would have that power under the 14th Amendment. Or let's forget murder, let's take theft. I suppose if I steal your money, I'm depriving you of property without due process of law.
Your Honor, we feel like the Congress would have the power to pass the law, but we feel like the courts would hold it invalid in that it had to do with a natural right rather than those rights arising from substantive power.
If you think the courts would hold it invalid, then I suppose you're saying you don't think Congress has the constitutional power to do it.
Whether the Congress has the constitutional power to pass a law stating that murder as such or theft as such would be prosecuted by the federal courts, we do not feel that the exercise of that power would be valid. No, sir. Just my opinion.
Mr. Watkins, I understood you to say earlier that the jurisdiction over the crimes charged in this indictment under 241 was reserved to the states under the 10th Amendment. Did I misunderstand you, or did you state that?
Mr. Chief Justice, I intended to state that the jurisdiction of this honorable court to review case in number 59 was conceded by the appellees, that certainly this honorable court has jurisdiction in case number 59. We do contend, and we're about to make that point, Your Honor, that as to case number 60, we do not feel that this honorable court should take jurisdiction of case number 60 on direct appeal. But certainly, in case number 59, there's no question about this honorable court having jurisdiction of the review in case number 59.
And that's under 241?
Under 241. Number 59 has to do with 241. Yes. And number 60 has to do with 242. Yes. Now, in regard to number 60 and that particular point, it is the contention of the appellees that it was in the mind of the federal district judge that the allegations from a factual standpoint in number 60 under 242 did not bring the private individuals properly within the indictment, and that he had before him simply a matter of fact that if the district attorney had charged that they flashed a badge or did some other thing, or even the aiding and abetting statute that would have brought them within the 242, that of course that indictment could have stood. And we feel like that was the thinking of the federal district judge at the time when he says that there was nothing alleged to make the private individuals in fact or de facto acting under color of law. Then the government contends here that because of the aiding and abetting statute, regardless of the fact that the indictment did not refer to the aiding and abetting statute, that the indictment on number 60 as against the private individuals should have been allowed to stand. We respectfully submit that the district court was dealing simply with the interpretation of the indictment and not a construction of the statute in that regard, and if the district court was dealing with an interpretation of the indictment, that on direct appeal it would not be properly before the court in case number 60, and that the court should not take jurisdiction of the case in number 60. In our minds, it's crystal clear that Section 242 clearly reaches the 14th Amendment guarantee having to do with action under color of law. And that, coupled with 371, which makes the private individual vulnerable for prosecution under general conspiracy to violate 242, and that without any overlapping, certainly, we feel that it was not the intention of the Congress that 241 and 242 deal with the exact same violation and a person be prosecuted twice for the exact same thing, which is protected in regard to the Fifth Amendment. But without overlapping, the officers can be prosecuted, as the district court held, under 242, that the private individuals be prosecuted under general conspiracy 371, which is, in cases is a felony. In this case, it would not be, because the object of 371 is 242, a misdemeanor, and therefore the charge against all the defendants under 371 in this particular instance has to do with a felony. Had to do with misdemeanor, but it could, in other cases, have to do with a felony. But that without overlapping, we have 242 as to the action on the color of law in regard to the officers, and 371 as to the individuals. Now, if the indictment had been properly drawn and directed that they could be prosecuted, the private individuals, under 242 also by the aiding and abetting statute, they can be prosecuted then on the substantive charge under 242 along with the officers, and all the officers and the private individuals prosecuted under 371 for general conspiracy. Then if we do not restrict 241 to federal type rights, it's simply an effort to increase the punishment, to go back and pick up 241, a felony charge, to seek to prosecute them, all the defendants, for exactly what had been covered in 242 and 371 and under the aiding and abetting statute under 242 also.
Well, I gather then, Mr. Watkins, you say this is not construction of the statute, but construction of the indictment, because the dismissal as to the private individuals turned on the omission of any express allegation under the aid and abetting statute.
Your Honor, Mr. Justice, that is our contention. As we understand it, if the decision of the district court was based in part on the interpretation of the indictment, that on direct appeal, there would be no jurisdiction in this honorable court. That's our understanding. But of course, we have already conceded the point that if the district attorney had charged those individuals, as we see it, with violation of the aiding and abetting statute as such, that indictment would have stood.
The aiding and abetting statute doesn't set out a substantive offense. You don't violate that statute. I don't.
That is correct.
Quibble, but I suppose it could be this failure to mention that statute. It could be something that could be maybe more appropriately remedied by a motion to make it definite and certain, or rather for a bill of particulars.
Mr. Justice Stewart, that may be correct. We feel like that the aiding and abetting statute, Section 2, Title 18 of the United States Code, has to do primarily with punishment. Perhaps it does. And though it was not specifically mentioned, it may have been the duty of the court to have taken judicial notice of the existence of the aiding and abetting statute. Trying to be completely as fair as I know how to be in answer to your question, Mr. Justice. I do not know the answer as to whether or not, simply because the aiding and abetting statute was not specifically referred to in the indictment, as to whether or not the court should have taken judicial notice of it. However, we do feel that it certainly would be unfair to place the district court in a position of being prosecutor as well as judge and seeking out the statutes under which the named defendants could be prosecuted. We respectfully submit, in conclusion, that the balance of power between the states and
Excuse me, Mr. Watkins, may I just get this point clear? May I just ask you this question? I gather that even though you concede that as to the private individuals, that this indictment had alleged the aiding and abetting statute, there would have been a good indictment against that.
if the facts also alleged, Your Honor, in the indictment, to such an extent that it could have been legally determined by the district court that such acts constituted aiding and abetting, yes, sir?
Yes, under 242.
Under 242,
242.
yes, sir, I do.
But I gather you also say, notwithstanding that concession, there's no jurisdiction here to review, because what the decision below turned on, dismissing the individual defendant, or the private individual, was the interpretation of the indictment as not embracing them because it did not make the allegation. Is that it?
Mr. Justice Brennan, that is correct. We contend that the decision of the federal district judge was based, at least in part, on the interpretation of the indictment, in that the government did not charge anything that he did, such as flashing the badge and Williams.
So that even if we were to disagree with you that it was necessary to have an express allegation, even if we were to say that we read the that an express reference to the aider and abetting statute was not required, you would still say, I gather, that we have no jurisdiction.
No, sir.
That this determination that it wasn't necessary expressly to make the allegation has to be made in the Court of Appeals and jurisdictionally can't be made here.
That is our position, Your Honor, that since it may have been based in part on an interpretation of the indictment and a factual situation was before the district court, that the matter of procedure would be not on direct appeal. That on direct appeal, the statute specifically authorizes review under certain cases, such as the construction of a statute or construction of the constitutional amendments or otherwise. That is our position, Your Honor. We respectfully submit in conclusion that the balance of power between the states and the federal government is necessary to continue and give the proper meaning and purpose to our great system of government. And here principally, as referred to in United States versus Williams, we are dealing also with that balance of power in regard to essentially local matters having to do here with solely natural rights between one citizen and another, that the 14th Amendment guarantee does not add anything to the right of one citizen as against another citizen in regard to protection of a wrong committed by one citizen against another, but that 14th Amendment guarantee, as well as the 15th, has to do with the prohibition against encroachment by the state or by the federal government in 15 in regard to these rights. Thank you.
Mr. General.
Chief Justice, and may it please the Court. Mr. Justice Stewart's question about Congress passing an act that applies to murder, in 45 of the government's brief in the appendix, you will see Section 7, which did just that, and Congress later repealed it. Section 7. And that was repealed later. So, I mean, obviously Congress decided they didn't have power to do that as such. The other question
When was it repealed?
1894.
But it limits a little bit.
They tried.
Narrowly than my hypothetical.
Yes, sir.
statute.
Yes, sir. But even that, it's obviously they let it go.
repealed.
The other question about the aider and abettor, I think, should point out that in 60, in each one of the substantive counts, second, third, and fourth, it is alleged that all 18, including the private individuals, quote, while acting under color of the laws of the state of Mississippi, is alleged in each one of those counts. And the theory was, obviously, relying on the aider and abettor statute. And on the...
Mr. Solicitor General, what about Mr. Watkins' point that even if nothing more than this is required to invoke the aider and abettor statute, nevertheless, as a matter of our jurisdiction, we can't say that. An appeal should have been taken to the Court of Appeals for the Court of Appeals to say that.
Well, we have set out in footnotes on page 9 and 33 of the government's brief cases, I thought it was perfectly clear that you didn't have to allege it specifically under the aid and abet statute.
Well, I know, but I don't think that's his argument. I'm not suggesting I agree with it.
Well, I
But his
understand.
argument, as I understand, Mr. Watkins, his argument is that whether or not the indictment was sufficient to embrace the aid and abet statute is something we can't decide here, because that's a question of interpretation of the indictment, and therefore not an interpretation or construction of the statute. Therefore, there's no jurisdiction on direct appeal.
And I understand his argument to be that when the district judge says that since you don't allege that one of the men flashed a badge, then the factual basis is lacking. What he really means is that unless you show that each defendant is a state officer, 242 doesn't apply. That's not a factual determination. That's a legal determination. That's a legal determination and a construction of the statute. There's no fact in that at all. And I say that the allegation that they acted under color of the law of the state of Mississippi, which is in each one of those three counts, is enough. The only other point I'd like to mention is this constant argument that, of course, 241 applies to 15th Amendment, but they say it's because of Article 1. But from all of the cases, Ginn, Myers and Anderson, Mosley, and all of them, they talk about the 15th Amendment. They don't talk about Article 1. Classic does, but Classic then goes ahead and talks about 14th and 15th Amendment rights just like everybody understands them. I don't believe it can be limited to that, and we would urge that the court reverse. If there's any question about technicalities on the indictment, that can be worked out on the district court level.
What effect does Cruikshank have on this case?
I take the position, Mr. Justice Clark, that Cruikshank went off on that one little point, as I remember. I mean, so far as I'm concerned, on the question about race not being involved, and that has always thrown me. But I did not rely on it one way or the other in our brief, because starting with Screws and Williams, I take the position that all of those cases now stand in a different category because they were all reviewed so thoroughly. And why do we have to go back again to them?
We wouldn't have to overrule Cruikshank?
No, sir. I think you can find that we've got it in our brief. I don't think, as long as we have Screws and Williams, I don't think we have any problem of overruling any case.
Of course, there wasn't an opinion in Williams. Court opinion.
It was a 4-4. It was, for all intents and purposes.
You mean Justice Douglas's opinion?
Justice Douglas's opinion. I think that the possibility is that the
what you do is you link Screws and Justice Douglas' opinion and Williams together.
Yes, sir.
For your position.
Yes, sir. I put the two of them together, and then I take it that you don't have to go any further than that.
But you have to put the two together. You can't stand on Screws alone, can you?
I think we have to put the two together. I do say that in Screws, which will come up considerably in the next case, I think that the whole purpose in Screws was to not be forced to throw the section completely out and to find a way that would make it constitutional. And indeed, when you read Mr. Judge's opinion, Williams, he uses that for that purpose, and we intend to use it with this.
Screws, Screws. Was it under 242?
Screws was on 241, 242. 242. It was 242 because it was a sheriff and an assistant.
Do you see any difference, apply that same reason in 241?
Well, I think that when you take the two together, the reasoning that upholds 242, which was that you have to put some limitation on this in order for it to be constitutional, the limitation is that you must allege intent to deprive the victim of his rights guaranteed. Specific. Now, in Williams, it was made quite clear that under the conspiracy statute, you get the same kind of intent. You don't conspire to do good.
Well, of course, you'd have to have a majority opinion in Williams. In other words, you see there's only two of us left.
Yes, sir. Yes, sir. Well, I think that's good enough for us. Thank you, sir.